Well, hi everyone. Thank you for joining me today. We're going to be talking about the 10 mistakes executors make and how to avoid them. And welcome to our Facebook Live audience as well. My name is Lynn St. and I am an estate planning and elder law attorney here in Washington State. So I will be trying to answer all your questions today. So for those of you who have a chat function in front of you, feel free to ask your questions in the chat and I will answer them either during our discussion today or at the end. And if you're on Facebook, just go ahead and put your questions and comments and I will do my best to answer those as well. For those of you who are joining us today, I want to let you know that we will be sending you a free probate checklist, and that will have some helpful information. And for those of you who stick with us toward the end, I'm going to go ahead and talk with you about a free gift that we have for you as well. So let's go ahead and get started. So this is about the 10 mistakes executors make and what you can do to avoid them. So first of all, I want to start by saying, well, what is an executor? I mean, are you in the right place? Do you know what an executor is? So in Washington State, we call it personal representative. We call it an executor. That's kind of a common term, executor. So that's a term I'm going to be using. And the executor is the person who administers a decedent's estate. A decedent is somebody who has died. And so typically what happens is once somebody has died, there's going to need to be some sort of estate administration. Very often it is what we call a probate. A probate is where a will is filed with the court. And fortunately, if you are here in Washington or in Idaho, probate can be a very simple process. I say simple, but what I mean by that is there doesn't need to be any court intervention. It doesn't need to be costly, like a percent of the value of the estate. In Washington, our rules, and in Idaho, our rules are just very much set forth. You do this, you do that, you do this, you do that. Oftentimes, when somebody is serving as an executor, they will work with an attorney's office such as ELG estate planning. Sometimes people try to do a probate process on their own, completely understandable. If that is you, we do have another recording that is about do-it-yourself probates. So our goal is to provide you as much information as we can so that you can make the best decisions for yourself. So let's go ahead and get started. 10 mistakes executors make and how to avoid them. One of the biggest mistakes people make is timing, taking too long. And we see this in a couple of different ways. One of the ways we see executors taking too long is they take too long to open up the probate. A probate should be opened up probably within a month to 2 months, maybe 3 months after the person has died, after the date of death. We encourage our clients, you don't need to do anything immediately after death. Deal with the grieving process. Your loved one has died. Take time to take care of yourself and that grief. Once you kind of feel like, okay, now you can move forward, that's the time to open up the probate. Don't take too long to do it. There are situations I've seen where people have taken a year, 2 years, or even more to open up a probate. And you can imagine what happens during that time frame of taking too long to open up the probate is, where are the assets? What have happened to the assets? Has somebody come in and taken the assets that they shouldn't have taken, either by joint titling or other ways? So, it makes sense, I think, that when somebody has died, then when you are ready in a month or two, move forward with administering the estate, typically through a probate process. Now, if you don't know whether a probate is necessary or not necessary, please reach out to your attorney. I know for our clients, we will meet with them, and if there is complimentary typically, and if there is no probate required, we're going to let them know that the estate plan was set up to avoid probate. So there's really not work that has to be done. It's kind of set up automatically. Lots of times clients don't know, well, is there a probate going to be needed or not? Reach out to your attorney. They will answer that question for you. Taking too much time. Now, when you are the executor, the real problem we see is that the executors take too much time to do their job. Serving as an executor is a job. Not only do you take an oath, but you have told the decedent in a way that you're going to carry out their wishes. So that's what you are obligated to do. And when people take a lot of time to fulfill their duties, you can imagine problems arise. So taking too much time, oftentimes how that we see that is people are overwhelmed. They don't know what to do, and they don't reach out to somebody to help them. If somebody's doing a do-it-yourself probate, they really might not know where to start or where to turn for answers. And if that's you, if you're finding it's just too much, you don't know what to do, then do seek out a lawyer to help you. When we're working with clients, and if they are taking too long, we will let them know that here's your list of things you should be doing. We actually provide our clients now with a checklist. Do this and do that and this and that and this and that. And we are here to help you, guide you through this process. The problems that we see arise are when people simply don't do what they are supposed to be doing. There are some very specific time frames that are set forth in the laws, in the probate laws, that say when something has to be done. For example, notices need to go out within a very short time frame. And those notices, if you're doing your own probate, you probably aren't sending them out. If the law firm is doing them, of course they're going to get done. That's why you hire the law firm, to make sure that it gets done. When I'm talking about taking too much time, the executor taking too much time, it may be that they are just not doing the things that they are supposed to be doing. And if they're not, for example, they need to redirect the decedent's mail to them. Has the person gone to the post office and done that? They need to perhaps ready the house for an estate sale, or prepare the house for sale, or you can imagine all these issues. They need to review all of the decedent's paperwork. What were their assets? So there really is a need, and it's really important that the executor take this job seriously and do it like a job. Don't shirk the responsibility, move forward, don't take too much time to do it. And if you don't know what is too much time, you'll kind of get a sense of that by, if there's other beneficiaries, they're going to start saying, what are you doing? What's going on? Why haven't I heard from you? You'll know if you're an executor, you're taking too much time, if the law firm is reaching out to you and saying, have you completed this? Have you done this? This was on your to-do list. Have you done that yet? And if you're not doing it, then you are taking too much time if your attorney is giving you that feedback. Now, I want you to know, if you are feeling like, I'm just simply overwhelmed by this job, it is a big job, I have no idea how big it was, you can step aside. You can say, I thought I was cut out for this, but I've learned that I'm not. So you can actually step down from your role as executor if you're finding that it is just too much for you. And there's no shame in that you've just recognized that you weren't right for the job. So I just wanted to let you know that, because lots of times people feel like, oh, I absolutely have to do it. And if you can do this job, go ahead and do it. But if you're feeling overwhelmed and it's just taking a toll on you, then maybe it is best for somebody else to step in and take over the job. What's another problem we see with executors? Wanting to distribute out the assets way too soon. I mean, everybody wants to get the money from the estate. So there is pressure on the executor to make distributions. An executor cannot make distributions until certain steps have been completed. Those steps include, like I mentioned before, notice has to go out, and it goes out not just to the beneficiaries and the heirs at law, it goes out to the state agencies, for example. More than that, notice must go out to creditors. So creditors have a 2-year period to bring claims against a decedent's estate unless something is done to shorten that period of time. So what do we do to shorten that 2 years? We shorten it down to 4 months. How we do that is that we publish notice in the newspaper, the county newspaper where the decedent resided, and that gives notice to any creditor to say, if you have any claim against this estate, you must bring it now. And you must bring it in this very statutory formatted way. The creditors have to do it exactly right. And if they don't do that, then their claim is forever barred. And that's just within a 4-month period. I mentioned earlier that the executor needs to go through the decedent's paperwork. You're looking for bills. Are there bills? Credit card bills? Are there any recurring monthly expenses going out, for example, on cars, etc.? Anybody who, or medical bills, anybody who is what we call a reasonably ascertainable creditor, that's someone that the executor should reasonably know about, we actually need to give them direct notice of the probate and of the decedent's estate. And through that process, we again can make sure that if they're a legitimate creditor, a valid creditor, and they filed a creditor's claim, that their claim will be paid or compromised. And if that person or that creditor does not bring a claim, then again, they are forever barred. Now, why is this important? The reason it's important is the whole idea with administering an estate is that you're wrapping up the decedent's affairs. You're making sure that any claims against that decedent, any creditors, that their claims will be, those claims will be paid if they are valid and legitimate. Well, why is that? So that the people who are actually ultimately going to receive money from the decedent's estate is going to keep what you actually distribute to them toward the end of the process. Distribution should be made toward the end of the probate process when it comes to money. Again, the reason for that is that you've got to go through this 4-month creditors claims process and make sure all creditors are going to be paid. You don't want to distribute out money before that happens. Another type of creditor, and this often is something that people don't have on their radar, so I want to make sure that you do, is tax returns have to be filed. So an executor might be looking at the decedent's tax returns and say, oh, there wasn't a return filed last year or the year before. I should talk to the accountant, should follow up on that. Why is that? If the decedent owed taxes, those have to be paid from the decedent's estate. And not only just back taxes, in the year that the decedent died, they may have, you as the executor might have to file a tax return if any taxes are owed. Where's that money going to come from? It's going to come from the estate money, the decedent's money. So you're going to want to make sure that any tax liability for the year of the death is also determined and paid if it's going to be paid, or sometimes there's going to be a refund. And if there's going to be a refund, that money is going to be put in the estate account. Making distributions too soon of money puts those beneficiaries in a place where if you made those distributions too soon and you overpaid somebody, you are going to have to say, oh, can I have the money back? Well, that might be a good luck. No, you're not going to get the money back because it's already been spent by the beneficiary. So if anybody is legitimately owed money, well, who's going to be responsible for paying that? You are, and you're going to be responsible for paying it out of your own money. So don't make the mistake of making distributions of money too soon. Now, what can the executor distribute early on in the process? Usually it's the decedent's stuff. Stuff meaning, personal property, household items, those sorts of things. So if there is a will as an executor, what you're going to be looking for is there a personal property list. A personal property list allows someone to say, all right, here is my, I'll say, china set. It goes to so-and-so. oh, I want my car to go to this other person. I want my tools to go to this other person. The stuff typically can be distributed really early on in the process. Why is that? Because typically it doesn't have a substantial value. If there is a very valuable type piece of personal property, that's another matter. But typically the stuff in the house can be distributed out. If there's any kind of firearms, that's a whole different subject. Lots of laws apply to that. So you got to be really careful about firearms and distributing those things. So estate sales are often something that an executor will have to put into place. Usually what happens before the estate sale happens or an estate sale company comes in, that the executor will allow someone to, or the beneficiaries to come in and to select among themselves the personal property items. So don't make the mistake of making distributions of cash, in particular of money, too soon. Next, what's another mistake executors make? That is not following the terms of the will. So it's really important. Your job as the executor is not to say, well, I really think mom would have wanted this, or, you know, mom had in mind that she was going to change the terms of her will, but she never really got around to it. You are obligated by law, and you gave an oath that you are going to precisely follow the terms of the will. You cannot alter the terms of the will and say, you know what, mom really wanted to disinherit that child, but she didn't get around to it. It's not your job. It was mom's job before she died to change the terms of the will if that's what she actually wanted. If she didn't do it, it's up to you as her executor to follow exactly the terms of the will. I mentioned earlier, you have to give notice to the beneficiaries and the heirs at law. Let's say that there are 5 kids in the family and mom said everything goes to the 5 kids equally. So everybody gets 20%. If one of those 5 kids is hard to locate because they're really estranged, they haven't talked to anybody in the family for 10, 15 years, they're still entitled to 20% of everything that's going to pass under the will. So it's your job as the executor to find them. That means you have to put on your detective hat and find that estranged sibling of yours. That might mean that you need to hire an heir search firm to say, I have looked for that person. And if you can't find them, then you might have to put that 20%, set it aside, and then it gets paid to the state in the unclaimed funds potentially until that 5th person is found, even after you've closed the probate. So don't feel like, well, there's an estranged child and mom really didn't want her to get it, even though the will says, so we're just going to divide it 4 ways, not 5 ways. You cannot do that. That is, you will violate your duties under the law, and you really, really don't want to do that. Another mistake executors make is not, if you're working with an attorney in particular, you need to tell the attorney what all the assets are. You can't say, well, here was an asset that was nobody knows about, so I'm not going to tell anybody about it, and either I'll just divide it this way, or no. It's kind of like I just mentioned, following the terms of the will. You have to gather up all the assets. Again, how do you know what all the assets are? You're reviewing mail, you're looking at if there's an estate planning notebook, you are, there's websites, for example, you can go to find life insurance. Did mom have any life insurance that you were unaware of? So you have to gather up all those assets, find them. That is your job. And then, especially if you're working with an attorney, you need to let the attorney know what all those assets are. You know, if you're dealing with a large estate, one that's taxable, and in the state of Washington, what that means is it's a little over 2 million, 2.193 million this year. If you have a taxable estate, then really critically important that there's an inventory done, you're working with an accountant, there's an estate tax return that's done, because the estate is going to owe the state of Washington an estate tax. And an estate tax is going to be owed not just on the assets that pass under the will, but assets that pass outside of the will. For example, a lot of assets don't go under the will. This is where people get really confused because they think, oh, well, the will governs everything. The will governs assets that are what we call probate assets. For example, a house or a bank account with no joint titling, investment accounts with no joint titling or pay on debt. What a will won't cover under its terms are, for example, a 401k or an IRA or a life insurance. Those might have beneficiary designations that pay far differently than what the will directs. And you as the executor don't have control over the direction of those assets, but you, because the beneficiary designation says where it goes, but you as the executor are responsible for figuring out, yes, there is a non-probate asset and it was $1 million and it did pay to this person and that person, because as doing the inventory and working with the accountant, it's your job to include on that inventory not just the assets that are passing under the will, but the assets that are paying by way of beneficiary designation and not going under the will. So when you get a more complicated estate, especially if it's a taxable estate like that, you definitely are going to want to work with an attorney and an accountant who knows how to do estate tax returns. So as the executor, here's the next biggest mistake, is they think they don't have to talk to anybody. They don't have to tell anybody what's going on. And technically, there's no requirement under the law that you have to tell your siblings. Let's say you're one of 5 siblings and you're the executor and the estate is going to go 20% to each of your siblings. The law doesn't require you to continually tell your siblings the status of the probate. In fact, what the law says is you have to give them notice at the start, and then you have to give them notice at the end when you're making the distributions. That might be what the law says, but is that a good idea? You know, everybody's situation is different, but as a general rule, it is a good idea to let your siblings know, let the beneficiaries know what the status is, what's going on. It could be as simple as saying, you know, right now we're in the creditor's claims period. It's almost over. We've only seen claims, you know, valid claims of 10, 20,000. It might be a good idea to give those other beneficiaries some idea of what the estate value is that is a probate asset. Like, you know, maybe they all know that here's mom's house, it's worth, you know, $500,000. They might not know anything about bank accounts and investment accounts. So you might want to say to them, you know, there are, what I can determine so far, there's a bank account, it's worth about $100,000 and an investment account about $200,000. You might want to share with them what the costs are, that, you know, that there might be a tax liability, or, you know, you are paying attorney's fees, not you, the estate is paying attorney's fees, because what's going to be distributed is the net amount, not the gross amount. You know, creditors have to be paid, taxes have to be paid, legal fees have to be paid. So if the gross estate is worth, you know, $800,000, you know, the net estate is likely to be less than that. If you are concerned, you know, you could always be conservative in your value but I wouldn't misrepresent it. You know, there may be reasons that you don't want to tell your siblings anything, but I think as a general rule, it's a better idea to be more transparent, let those beneficiaries know the status, what's going on, what the approximate value is. And that way, you know, it's just going to reduce some of the tension, most likely. Now, on the other hand, they might say, oh, I want my distribution right now. But fortunately, you know that you can't give them a distribution toward the end of the process. I do want to say that sometimes executors will give modest distributions. But if they do that, make sure that it is a fairly modest distribution during the process. And it's almost like a buy time, keep people happy, because, you know, maybe at the end of the process, they're going to get $200,000. is what's going to go to each beneficiary. And right now you can distribute out, 10 or 20,000. You will know better than most what your family dynamics are and whether that's going to help things or make things worse. And you should just hold off to the end. And also, if you have questions about that, talk with your attorney. Whenever we make distributions, we like to make sure that whoever receives it signs a receipt so that they can't claim, well, I never got that from you. Obviously, if there's family dynamics are difficult, you're really going to want to follow your attorney's guidance on whether you should make any sort of modest early distribution. All right, next. I kind of alluded to this mistake before when I was talking about inventory and what goes under the will. And this is a mistake that anybody could make because it is really confusing. And what that is confusing probate assets with non-probate assets, confusing the will with what it governs with what it does not govern. So that confusion, very understandable. You might be the executor and you're saying, well, under the terms of the will, it says, everybody shares equally. And I mentioned before that if your job as the executor is to be aware of non-probate assets, the life insurance policy, the 401k, the IRA, and you as an executor don't control that asset, the beneficiary designation on that non-probate asset does. So your job as an executor is to know about it, put it on the inventory, but your job isn't to say, hey, you received mom's IRA, it was directed 100% to you, but it really is supposed to be divided 5 ways. Because that's not how it was set up. And if mom intended that IRA to go 5 ways, then that's going to create a lot of complications. Person receiving the IRA, I don't even want to get into the complications. But what I want you to understand as the executor is that beneficiary designation on that IRA controls, not the will that you are administering. So one of the ways to make this easier is that before the death of the person whose estate you're administering, that you sit down with them and maybe their attorney, and you say, I just want to understand what the estate looks like, what are the assets, what my job is going to be. That way it's going to be much easier for you when you have to assume that role. And also that way you might get a better education about what probate versus non-probate assets are. And by asking these questions, you might find out, or the decedent before their death, your mom, for example, might find out, oh, I didn't know that I shouldn't set up that non-probate asset to pay to just one person. I really wanted it to pay to, all 5 of you. So that's, I guess, planning in advance of death is one of the best things that can be done to make your job easier as an executor. So if you do have that opportunity, it's not like you're saying, mom, where's the money now? You're saying, I'm your executor, mom. I want to make sure that I do exactly what you want me to do. And I want to understand my job so we can sit down and go over it together. Can we talk to the attorney and make sure that we're all on the same page? That's probably the best advice I give you, is do these sorts of things in advance of somebody's death. Let me give you one other example of the confusion between probate and non-probate assets, and we see this very, very commonly. Let's say that investment account mom has is worth, $200,000, $500,000, whatever it is. And what they did on that investment account, what mom did, was for ease of estate administration, rather than just having it directionless so it would pay to the estate to be distributed as a probate asset under the will, instead, mom put somebody, one of the kids, maybe even the executor, on as a joint owner of that asset, a joint owner with rights of survivorship. So what happens then on the death of mom is this joint owner now is the owner of the entirety of that account. Now, the question that has to be asked is, did mom do that so that mom would disproportionately benefit that one child because that was mom's favorite child? Because that child who's the joint owner may say, that's why I am the owner of this account, because mom wanted me to receive it all myself. Or did mom put this person on unwittingly, not realizing what the consequences would be of joint ownership with right of survivorship? And in fact, would mom have preferred that, had she known that money is going to be divided 5 ways, just like the terms of the will? I don't know the answer to it. The executor might know the answer to it, but this situation I just described really gives everybody else the opportunity to claim that no, that account should pass under the will, and how you're treating it as your own asset is wrong. So again, this kind of comes back to doing the right estate planning beforehand to make sure that these sorts of situations, these sorts of problems don't ever arise. And if there is a joint ownership, we typically tell clients, if you want to put somebody on the executor on an account joint with right of survivorship, do it on a modest account. For example, a $10,000 account. So they have immediate access to funds to pay for burial, that sort of thing. Don't put somebody on as a joint owner on a larger account, because it can really lead to lots of strife and disputes and problems with your beneficiaries once you're gone. Next mistake. Really, this next one is not collecting all the estate funds and putting them into an estate account. So as an executor, what you might not know is that you have to get a tax ID number. And the tax ID number is a separate number that the IRS issues for the estate. So if there are monies to be collected, let's say, for example, one of the monies is an account that was a joint ownership, and you decided to, divvy it up. Either you're going to pay it directly out, or it's going to go to an estate account. But if mom had bank accounts set up as they should, or if the house is going to be sold and the proceeds are going to go somewhere, those proceeds need to go to an estate account. They should not go to an account that is your account, for example, with your social security number. That is going to cause a lot of confusion, a lot of issues for you on your tax returns. It's not your money, it's the estate money. So do make sure that an estate account is set up if the estate is going to be, if you as the executor are going to be collecting money from any of these assets that you're selling or that were the decedent's assets, and that those monies are going to be coming into the estate to pay creditors, to pay taxes, to pay for whatever has to be paid for. And then ultimately at the end, there's going to be one bucket of money from which what you do will make the distributions after all the work has been done, all the creditors paid. And that makes it a lot easier when you have an estate account, because it's clear that here's where all the money is. It's in an estate account. And if any of the beneficiaries want to know, well, where's all the money? Well, clearly you can see it was all collected and it was all put into an estate account, not my account, not anybody else's account. It went to the estate account, and now it's ready for distribution, and everybody gets a check from that estate account at the end of the probate process. So not getting help from a qualified professional is a big mistake executors make. As we've been talking about, and that this job of an executor has a lot to it. Are you an accountant? If you are an accountant and you file tax returns, maybe you can figure out the tax issues. Are you a lawyer and do you know estate planning? Then maybe you can do all of this work that I've been talking about as an estate planning attorney would give you advice. So those are the two biggest areas of professional advice that I think that every executor should avail themselves of. I mean, a lot of times people try to do the work on the cheap, totally understand that, but sometimes doing the work on the cheap, not getting professional advice is going to drag out the probate process longer. It's going to result in perhaps you having your own personal liability for not doing things right, like not filing a tax return. You distributed out the money, IRS is owed money. Where's it going to come from? It's going to come from you. So one of the things as an estate planning lawyer, we really want to make sure we do is protect our executor from their own personal liability, from doing things that they don't realize are wrong. So, you know, if you have any questions, do seek out the services of an attorney, somebody that does probates. Don't use a general practitioner to do this. A lot of general practitioners will say, hey, probate's easy, I can do this. That may or may not be the case. You know, an attorney is supposed to be looking out after your interest in protecting you. And that's one of the reasons that we recommend our clients also use an accountant. As a law firm, you know, we are not accountants, and so we recommend using a CPA that knows how to do these types of tax returns. So do reach out to a qualified professional and get help. One of the big mistakes that people make is what we call self-dealing. And self-dealing goes along the lines of not following the terms of the will, or maybe as the executor, you are going to say, I am following the will, I'm just interpreting it in my favor. However you want to characterize it, that's self-dealing. You can't do that. So, for example, let's say you're the executor and then there is a house to be sold and you're not the only beneficiary of the estate. You've got, you know, there's 5 of you that are going to inherit from this estate, and it's all going to be equal. But you really want to, you know, be the owner of this house, and you're the executor, so you're the one that changed the keys on the house. You're the one handling, paying the utility, making sure the insurance is on the house, and handling the estate sale. You're doing all of that, and you're thinking, well, you know, I could just be living in this house too. Frankly, if you're living in that house, you should be paying a rent on that house to the estate. And then when it comes to the time of what are you going to do with the house, you say, well, I would like the house. I think I'm going to sell it to myself for a really good deal. You can't do that. You have to sell it to yourself for fair market value. And is the tax assessed value fair market value? Maybe, maybe not. Is a comparative market analysis you get from the realtor fair market value? Maybe, maybe not. The safest thing that you can do is actually pay for an appraisal. Get an appraisal that says, this is what the house appraises for, this is the value. And if that house appraises for $500,000 and it's going to come to you, then aside from the little details of excise tax and this and that and recording fees, you know, let's just take 500,000 as the round figure. You know, each of your siblings, the 4 others, are going to get $100,000. You know, you have 100,000 equity in the house, but you're going to have to either pay from your own cash or from your own resources the amount of the money that the house is really worth. You can't get a good deal for yourself. That's self-dealing, and that's not allowed under the law. Maybe your siblings say it's fine, maybe not. I just certainly wouldn't recommend that you do that. Last mistake is kind of along the same lines of the self-dealing, which is just not being fair to the other beneficiaries for how you are handling estate assets. You know, and it's really funny, when you're dealing with an estate administration and when you're dealing with siblings, sometimes it's not the money that's ultimately going to be distributed that's the biggest deal. It's the small items. It's the personal property items that have value. And they might have value to you, sentimental value, but they also might have value to your siblings or to somebody else as sentimental value. And so just because you're in the position of executor doesn't mean that you get to have first pick to any personal property items. You have to be fair, you have to be equitable, you have to do this objectively as you can. And you can talk with your attorney, you can talk with an estate planning company. There's a lot of ways, a lot of systems that people set in place to how to distribute property. Just know that you can't go in first and grab everything you want and benefit yourself first. Some of the systems in place can be like the estate company comes in and they place values on everything. And then all of the siblings come in and, you know, in a particular order, you know, you're allowed to bid. I want that item for $100, that item for this. Or maybe there's a numeric system where you haven't put actual values, but, you know, maybe, you know, the youngest goes first and you go through the order and they select, or, you know, there's got to be some semblance of reason and objectivity to these personal property items, especially if they're going to be contentious and there's more than one person that wants it. So do not, you know, give yourself first dibs on things, so to speak, because, you know, these are the things that really cause problems, is the little things. Even though you might be 5 grown-ups, sometimes when the siblings get together, the dynamics kind of devolve back to the childhood issues. I'm sure you all know what I'm talking about. So do everything to protect yourself about that and make things as easy as possible for yourself. You're the executor. So to kind of insulate yourself from any of those sorts of criticisms, do things right, don't do self-dealing, be fair, follow the will, do everything that the statute requires you to do, use legal counsel, use accountants. And if this all sounds like a lot, it is. So, you know, give yourself a break in terms of, you know, you're not perfect. All you can do is your best, but do make sure that in doing your best, that you're holding yourself up to the standards that the law requires. So let me take a look here and see if there's any questions. First one is, if someone has a legal will, don't they have to open a probate hearing upon death? Excellent question. And the answer is not necessarily. So if somebody has a will, the law requires that the person in possession of that original will file it in the county where the person was a resident. Now, does there have to be a probate? Are there assets that are going to pass under the will? Or are all of the assets set up to pass in a way that is not a probate type process? Let me give you an example. So let's say that the assets of the estate consist of a $100,000 bank account, that it's just in the name of the decedent, and there's no pay on death direction, and a house. That composition of the estate will require a probate. Yes. Let's take the same assets, but change the facts up a little bit. The bank account is set to pay on death to whoever is going to receive it. So we really don't like the situation when anything pays on death to 5 people, and I'll explain why next. Your house can have a transfer on death deed where it also pays on your death, transfer on death deed. That's a deed that's recorded before death, but upon death, it acts just like a bank account that's pay on death. The county already knows, hey, the title of this house is supposed to go wherever it says on the transfer on death deed. Why I hesitated when I said, we usually don't like a transfer on death deed to go to 5 people. Why is that? Because that's a big committee. And if there's 5 siblings that are going to receive a house, you can bet there are going to be problems, because there is a committee, there's no one in charge of carrying out, you know, the sale or whatever has to be done. But if instead that the beneficiary of the estate is 1 or 2 kids, then okay, then we might set up this estate to avoid probate. The will say everything goes to the 2 kids equally, but we intentionally set it up to know that nothing will ever have to go under the will, because instead what we've done is pay on death, bank account to the 2 kids, transfer on death the house to the two kids, assuming they get along, and then there will be no need for a probate. So filing a will or having a will does not necessarily mean that there is going to be a probate. Oftentimes we set up estate plans to avoid probate if we believe that there's going to be no benefit from a probate. The will does have to be recorded in the county, but there won't need to be a probate in many situations. And what this all goes back to is setting up estate planning in advance before death so that things will go much easier, much more smoothly, even without a probate upon somebody's death. And that's done through a good estate plan. Next question, regarding firearms, who will we contact to make the transfer legal? We have a number of unregistered firearms that have been handed down. That's such a good question. There are actually law firms that specialize in firearms because of the regulations that are involved with that. You've probably heard of law firms that set up firearms trusts. What I would suggest is, working with the attorney that you are working with, and just know that they may need to help you reach out to an attorney that specializes in firearms, because we want to make sure that all federal and any state regulations that might exist are complied with. So that is one part of how you would do a probate. Sometimes people may give firearms during lifetime before death. If that's done, then the burden and the legal responsibility isn't on the executor. Was that done right by the person? I can't say that it was, but sometimes that's how people just deal with things themselves before death. So firearms is something to be really aware of, as your question suggests. Definitely need the help of an attorney who specializes in that. And if your attorney doesn't, then the attorney should help you figure that out. And it might mean hiring an attorney who specializes in that. What if the non-probate items were needed for the estate to be solvent? That is a great question. Sometimes those non-probate items need to be grabbed and captured and be brought back into the estate to make it solvent. And there is a procedure and a way to do that. So not all non-probate items necessarily will be able to be brought back into the estate to make it solvent. For example, if life insurance pays to a beneficiary, life insurance is not subject to creditors' claims. Other assets that are non-probate, like if they pay on death, like an investment account or a bank account, those might need to be grabbed back into the estate to make it solvent to pay for claims. So in that situation, definitely a good idea to be working with an attorney to help you with that. That's a really good question. All right, so for those, I think I mentioned at the start that everybody is going to be getting this probate checklist. And for those of you who are still with me, what we are going to be doing is actually sending to you a certificate for, if you wish to ask more questions of us, for a complimentary consultation with us, ELG Estate Planning. It has a value of $375, and I encourage you to take advantage of it. We just reach out and contact you, make sure that we're the right law firm. We're not the right law firm for everybody. No one law firm is the right law firm for everybody. But we want to make sure that you are well served. So if we're not the right law firm for you, then we will definitely give you recommendations for who will serve you well. But we do typically charge a consultation fee for those who are receiving the certificate. And once we've reached out to you and we know that we may be the right law firm for you, then we offer that complimentary. That's a way of saying thank you to you for listening, for participating today. Feel free to give us a call. We're at 509-468-0551. And then we have a lot of information that's available. It's on our website, www.elgwa.com. We also have a YouTube channel, which has a lot of information as well. And so I hope that you found all of this useful and helpful. And if we can, be of service to you, please just let us know. Thanks everybody, and stay safe.